All right, good morning, everybody. We ready to go?
Yes, Your Honor.
Yes, Your Honor.
All right, first matter is Oki. Clark will be on deck. All right, what does the state feel is appropriate on this matter?
Yes, Your Honor. With Mr. Oki, we're asking for $5,000 bail, pretrial supervision, and testing. Defendant has lengthy criminal history going back to 1992, has history in Nevada, California, and Montana. Most recently, he had a misdemeanor conviction for drawing a weapon in a deadly manner and failed to register in Reno Justice Court and failed to register as a felon. A citation for drinking in public from Reno Municipal Court, where he had a failure to appear warrant. Also had a misdemeanor conviction for sit or lie in a doorway in Reno Municipal Court. 2024 had a possession of drug paraphernalia conviction in Sparks Justice Court, as well as drinking in public in Reno Municipal Court. 2023, much the same, similar convictions for sit or lie in doorway, drinking in public, another drinking in public, another drinking in public, destruction of property. Also had a gross misdemeanor destruction of property, gross misdemeanor conviction in 23. Going back throughout his history, while he has some history of violence, frankly, the most concerning felony conviction was from 99, which is a robbery. But over the last 5 to 10 years, similar types of substance abuse issues, and a number of failures to appear as well in the last few years. So therefore, we believe that bail and supervision are appropriate. Thank you.
Thank you, defense.
Thank you, Mr. Oki's mother was, we were able to speak with her this morning. She verified that he stays with her and that he's been working doing day labor. Mr. Oki has some insight into his struggles over the past few years with substance use disorder. He completed Crossroads, but that was about 8 or 9 years ago. And so he does need some help with his substance use disorder, which, as is reflected by the state's recitation of his criminal history, has been causing him some challenges in the community. With addressing that substance use disorder, either through a program with, I don't know what type of case this will eventually be filed on. It's a fairly small amount. So this case may not be appropriate for an inpatient order. However, supervision and certainly testing would be helpful in addition to guiding Mr. Oki to additional treatment resources so that he can manage his substance use disorder would be a less restrictive option than money bail, which working day labor and staying with his mom, he's simply unable to afford.
Great, thank you. With that risk score and that criminal history, as we know, the state has a compelling interest in both the appearance of the defendant and him remaining crime-free. And right now, they've shown by clear convincing evidence that bail is the only means to ensure that. So it'll be set at $6,000. Random drug and alcohol testing, pretrial services supervision, no bail laws, make all court appearances. I will allow him to be released. Yes, this may be, if it's filed a misdemeanor, this won't matter, but if he stays in as a felony, it will. Or to residential or sober living with IEP and support by an evaluation. Next court date is February 6th. That's Friday at 9 for the filing of the criminal complaint. We'll see you then, sir. Clark and then Flar.
Or to a program.
Okay.
Okay.
Oh, on February 6th. Right?
Yeah, it's the next court date.
Okay. Thank you, ma'am.
You're welcome. You know, yes.
All right, first you have a citation, sir, that we need to address. You were charged with possession of drug paraphernalia in that citation. I need you to plead guilty, not guilty, no contest.
Yes. Not guilty right now. Not guilty.
Sorry, sir, I didn't hear you.
Not guilty.
Not guilty. Okay. We'll set that for pre-trial. When do we do such things on citations? Okay. All right. Thank you. All right, while we're getting that date, we'll talk about your new domestic violence charge. Actually, we're going to keep these cases together, the paraphernalia and the domestic is what we're going to do. So was Steve is appropriate on this matter?
No, so first I would note that that our office spoke with the victim in this case. He is not asking for a no contact order. Says he, quote, needs to talk to him, and he's not concerned for his safety. I would ask, sorry, briefly, is he on, is Mr. Klunt on the call? I had some information that he may be present.
No.
Okay. Based upon that, and frankly, I was unaware of the citation until the court just mentioned it. His criminal history shows no prior criminal history as far as I can show. I guess that's realistically because the citation didn't show up as an arrest. So based upon the fact the victim is not asking for no contact order, the state is prepared to concur with an OR release. We would just ask that he not possess any weapons given the allegations of violence here. And it may be appropriate to just have him do check-ins with the court to ensure that he's present at all future hearings.
All right, thank you. Ms. Raines, any objection?
No, Your Honor.
So, sir, because of the paraphernalia, I'm going to include a drug testing condition. So you released on your own recognizance range of drug testing with pretrial services, supervision, no firearms. Check in with them as ordered, obey laws, make all court appearances. February 6th at 9:30 a.m. for both of your cases.
Yes, sir.
We'll just figure that out. See you next week. Flar and then Vought.
More instructions.
Hi, Ms. Flar has a few cases here. She has a domestic where she failed to appear. The bail is now $5,000. What does the state feel is appropriate on that matter?
Yes, Your Honor. So we are asking that the bail remain at $5,000 on that case. She's been outstanding for about 3 months now on that case. We're going to ask for additional bail in the other case and can address that when the court asks for that. But I believe that previously there was a no contact order that except for communication regarding a child on that. And so I believe that should be still standing, a little bit unclear from my notes. But again, given the fact that she's been outstanding on that order show cause for about 3 months, we believe that the bail is appropriate and ask that it remain.
All right, what do you want in the new case?
Yes, Your Honor. On the new case, we're asking for an additional $5,000. The defendant has criminal history going back to 2018. I show an arrest there for failure to appear. Had felony convictions in 2019 for obtain, use ID to avoid pros, 2 of those, as well as a possession of controlled substance. And then 2024, she had misdemeanor conviction for possession of drug paraphernalia and false statement, where she had a failure to appear, had another failure to appear arrest in Sparks, as well as a failure to appear in Reno Municipal Court arrest, and then that conviction for domestic battery that we were just discussing. So clearly an individual who is at risk to not appear in the future given her conduct here and in the past, and a risk to the community based upon her criminal history. A lot of these obviously these types of false ID and trying to skate from appearing in court, but again, also issues with drugs and violence as well. So we believe that an additional $5,000 is appropriate on this new case.
All right, what does the state feels appropriate? First of all, sorry, Ms. Flar, I need to talk to you. I don't have a public defender application in the new case. Would you like to apply for the public defender?
What was that?
Do you want the public defender to represent you on the new case?
Yeah.
Okay, you previously had the public defender, so I'll go ahead and appoint it. Ms. Raines.
Thank you, Your Honor.
Possibly ask for like a lower bill.
Yes, that's what I'm doing. Your Honor, Miss Flower lacks financial resources to post any money bail on either of those cases. She's been trying to get her social security number, which she needs in order to secure steady employment. She's been helping a friend do some cleaning sort of on the side while she works through those barriers to getting legitimate, sustainable employment. She did provide a reference this morning, although unfortunately we were not able to speak with him. But she does have ties to the community. And again, she lacks the financial resources to post any money bail. We would argue that there are less restrictive options than money bail to ensure her appearance for future court dates and minimize any ongoing risk to the community by supervision by pretrial services.
All right, thank you. Given her risk score, given that she committed this offense while having the suspended sentence in this case and the failure to appear, the failure to comply, history, the state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community, appearance of the defendant will be set at $6,000 in the new case. Bail will remain as set in the old case. Pretrial supervision, no bail laws, make all court appearances. Both cases are going to be set for February 4th at 8:30 a.m. in front of Judge Clifton. One for an order to show cause, one for an arraignment. Thank you. We'll see you then. Vaught and then Maroney. Mr. Vaught also has two cases. One is a DUI, failed to appear for the MSC. And then we have the new charges. What does the state feel is appropriate on both these matters?
Yes, Your Honor. So in the new case, the contempt of court, I would note, first of all, that the defendant scores an MPRA score of 14, which is extremely high. We're asking for $10,000 on bail on that case, given the fact that it's disobeying a court order. We'd also ask that he be supervised and have no contact with Melanie Butler, who was the one who was the subject of that no contact order. He on the older case, the DUI case, again, he had pretrial violations from back in November on that case. So given that, it also shows two instances of in the last few months of the defendant failing to comply with court orders. He also has a misdemeanor conviction for disturbing the peace in 24, as well as an arrest for resisting. He had a 2019, or had two 2019 misdemeanor convictions for battery, had another DUI back in 2014. So we believe that in addition to the $10,000 on the new case, the no contact order, pretrial supervision, and testing are appropriate. On the old case, it appears to me that the failure to appear warrant was set at $5,000. We believe that that should remain. It's unclear to me if there's any conditions other than testing on that case, but any conditions that appear on that DUI case, we'd ask that they remain as well. Thank you.
Thank you. Defense.
Thank you, Your Honor. This morning, our investigator was able to speak with Mr. Vaught's father to verify his residence. He also helps caretake his father, who is 82. And so Mr. Vaught received points on the MPRA for residence, although I see that his father didn't clarify how long he's been there, but again, clarified that he has a residence. Mr. Vaught was expressing some confusion. It was his understanding that he had not missed court, that he believes that he had attended all scheduled court appearances. So clearly it's a misunderstanding or miscommunication, but he indicates that he did not willfully fail to appear for that MSC, and so would appear as directed in this matter and as well as that matter to address his ongoing court obligations going forward. And he would obey the conditions going forward of no contact and any other conditions that this court imposes as necessary to protect the community and ensure his appearance for future court matters.
Okay. Best predictor of future behavior is past behavior. Defendant scored a high risk on the case, the DUI with our court, but he was released on his own recognizance. He was ordered to check in with DAS for supervision. This is back in September. He failed to do so. Did come to court at one appearance, was told again to be on supervision, did not check in with DAS for supervision. We had a second violation report, and then he failed to appear in November and has not contacted the court. So unfortunately, the facts belied the defendant's statements and show that he is in fact a high risk. He's now a 14, I think they said on that one of the arrests. Yeah, 14 on the risk score. So that puts him in a less than a 50% chance of making court appearances and being compliant, as seen by his actions. State shown by clear and convincing evidence that bail is necessary to ensure the safety of the community. The appearance of the defendant in the new case that was set at $10,000, random drug and alcohol testing, pretrial service supervision. Bail laws make all court appearances. February 6th at 8:30 for the arraignment on that case. New MSC is February 3rd at 9 a.m. on the old case. The DUI and bail remains as set on that matter. Thank you.
And Your Honors, I apologize. Was there no contact order with Ms. Butler on the new case?
Yes.
Okay.
Maroney and then Bergstrom.
Your Honor, I'm asking to waive Mr. Maroney's appearance.
All right. What does state feel is appropriate on this matter?
Well, Judge, Your Honor, I'm just catching up with that last case. Mr. Maroney.
No problem. Yes.
Yes. So, Your Honor, with Mr. Maroney, we are asking for $100,000 bond-only bail, pretrial supervision, no firearms or weapons, as well as testing for alcohol-controlled substances and GPS house arrest. The defendant, I understand, scores an MPRA of 2. I think this is one of those interesting ones where there's a lot here that is just barely outside the MPRA analysis. So the defendant has history going back to the 90s. He had a 92 conviction for battery in Reno Justice Court. Had a 95 conviction for battery. It says battery with a deadly weapon, but it appears it was resolved in Reno Justice Court with 90 days jail. So I suspect that's just a simple battery. Had a misdemeanor conviction for domestic battery in Reno Justice Court in 96, a misdemeanor conviction for obstructing and resisting in Reno Municipal Court in 99. 2003 had a misdemeanor conviction for domestic violence and disturbing the peace in Sparks Justice Court, as well as a misdemeanor conviction for intercepting a phone call in Sparks Justice Court. 2005 had a felony conviction for aggravated stalking in the second judicial. He had a 2012 domestic battery conviction in Sparks Justice Court. It looks like an intimidating witness charge was dismissed on that plea. Then probably most concerningly for this case as well, he had a felony conviction for possession of a controlled substance, 42 grams plus in the second judicial. He had a battery with a deadly weapon that appears to have been dismissed due to inability to serve the victim. That he was also arrested for at that same time. However, again, he is on supervision for a controlled substance case. And here we have him with multiple sales of controlled substances, a relatively large amount, almost 400 grams total weight of methamphetamine. He has a firearm that is stolen. So based upon the lengthy criminal history, the prior history for violence, the prior history for controlled substances, we believe that he is absolutely a risk to the community. Part of, again, we oftentimes see people here talking about how they are addicted and the troubles that causes them in their life when we see before them. And here we have an individual who is actively engaged in sales and firearm possession in this community. And so therefore we believe a high bail is appropriate, as well as, again, all of those conditions to ensure that he appears. And again, this individual who's doing this all while he's being supervised for another drug offense. So with that, I'd submit it, Your Honor.
All right, thank you, Mr. Raines.
Thank you, Your Honor. Mr. Maroney does score as a 2 or a low risk, and he is on supervision. I think cuts both ways. Certainly, it's a negative, but it also demonstrates that he's been supervised. He indicates that prior to this arrest, that he'd been doing okay on probation, and that he'd been on probation and parole in the past and had completed that community supervision. He has strong ties to the community. He has a residence. He has full-time employment. And he indicates as I think is clear from the probable cause sheet, he knows that he's in trouble, accepts that, and plans to take responsibility. He's hoping to tie up some personal affairs in anticipation of what might be an outcome in this case. But that being said, he is still a low risk, and understanding that these are serious charges, we would first ask for an OR, but in the alternative, a bail in the amount of $10,000. Again, also recognizing that he's likely to remain in custody on the probation hold, but at least with regard to this matter, there's sufficient basis for the court to have a much lower bail, if not an OR, based on that risk score before the court.
All right, thank you. The state's shown by clear and convincing evidence that bail, even outside the defense ability to make it as necessary to ensure the safety of the community appearance of the defendant, be set as requested $100,000. Random drug and alcohol testing, no firearms, check-in with pretrial services as ordered. No bail laws make a court appearance. It's February 6th at 9 a.m. for the filing of the criminal complaint. We'll see that. Thank you. Bergstrom and then Hess. All right, would Steve feel it's appropriate on this man?
Yes, Your Honor. In this case, we're asking for $20,000 bondable bail, pretrial supervision, no contact with the victim, Charles Balzer, or the 9025 Matthew Street address. The defendant has fairly lengthy criminal history, had most recently a by-possess stolen property arrest in 24 that was no issued, had a failure to appear arrest in 2023, had a felony conviction for possession of a controlled substance in 2022, had a misdemeanor conviction for disturbing the peace in 2021. That was in Douglas County. Also had an arrest for contempt and possession of a dangerous drug. Looks like it was dismissed. Has older history in the state of California, including a felony conviction for possession of a dangerous weapon, with some probation violations and failures to appear. But given the kind of brazenness of this crime, as well as, again, the allegations here and prior issues, we believe that bail is appropriate and ask that you set it. Thank you.
All right, thank you, defense.
Thank you, Your Honor. We were able to speak with Mr. Bergstrom's references this morning. He receives 2 points on the MPRA for a residency. He is an out-of-state resident, but just barely. He lives in Beckworth, so not far across the California border. It would be able to return easily for any future court appearances. He is very motivated to address this matter. There is a ownership of the trailer in question dispute that, again, he's very motivated to have his version come to light in terms of who was the rightful owner. He has been working full-time. He's connected with one of the electrical unions, has a working phone that actually his girlfriend physically has. So multiple ties to the community, girlfriend, other family members, and by community, it's the greater Northern Nevada, Eastern Sierra region. He can get back. He indicates that in the past, although he does have a criminal history, that absent traffic tickets, that he has been able to complete court requirements and appear for court appearances. Again, he is highly motivated to answer to this case and sort out the factual basis going forward. So looking at his ties to our area, he would be closer to a 6, still in the moderate range, with just some check-ins with pretrial services. That would be the least restrictive option before the court this morning, to ensure that he appears for those court dates.
All right. Again, focusing on the defendant's recent behavior with this court, he has those citations in 23, 24, 24, 25, 25. And in all but one of those, he had a failure to appear. So given that performance, the state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community appearance of the defendant said it. $20,000, no contact, separate criminal offense pursuant to NRS 1784845 from maximum 120 days. Pretrial services supervision of bail laws make all court appearances February 6th, defense next court date at 9 a.m. We'll see you then, sir.
Sir.
Hess. And after Hess will be Turk. Hess, Turk, and then Poole. The state feels appropriate on this matter.
Yes, Your Honor. So at the outset, I would acknowledge that he's got an MPRA score of 2. I don't think he has prior history. However, the state is asking for $25,000 bondable-only bail in this case, given the extremely concerning and dangerous circumstances here. But also ask for pretrial supervision and no contact with the Silver Legacy or the row where this occurred. Obviously, a very concerning case when someone it appears there's some sort of argument, unclear exactly what the circumstances of that were, but in response, the defendant pulled an AR out of his trunk and fired a round, causing damage within the structure. So that there were a number of other witnesses in the area, and given that sort of violence within this community, we believe the defendant's a risk to the community, and believe that bail, as well as pretrial supervision and no weapons and no contact with the row casinos would be appropriate. With that, I've submitted.
Thank you, defense.
Thank you, Your Honor. The conditions of no weapons, no firearms, and no contact with the row, or even the downtown corridor of Reno would be the least restrictive options before the court. We were able to speak with Mr. Hess's reference. His mother verified he has a residence in Carson City. So again, that mitigates his need to even be anywhere near downtown Reno, absent attending court appearances. He is employed as a pipe fitter, and as indicated by the state, he doesn't have any criminal history. There's no reason to believe that he would fail to appear in this matter. And although certainly concerning, the events surrounding this arrest, his danger to the community would be mitigated by being prohibited from possessing any firearms and making arrangements to surrender any in his possession immediately upon his release from custody. So we would ask for an OR with those with the conditions the court believes necessary to achieve those goals.
All right, thank you. Unfortunately, with the county eliminating the DAS officers, there's no effective way to enforce a no weapons clause. Therefore, the state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community, the appearance of the defendant set at $25,000, no contact with Silver Legacy, residential confinement in place before release, no firearms, checking with pretrial services order, bail laws, make all court appearances. February 6th at 9:30 for the next court date. We'll see you back then, sir. Thank you. Turk and then Poole. The state feels appropriate on this matter.
Yes, Your Honor. So in this case, Mr. Turk scores a 9. However, I would note that his criminal history appears to be fairly limited. He has a 2020 2 arrest for failure to appear, failure to comply. That appears to probably be on a citation from what I can tell. Has some older citation history out of California. Given that, we are not going to object to an OR release for Mr. Turk. We would ask that he be subject to pretrial supervision as well as comply with any CPS requirements. It appears they were involved in the case. And with that, I would submit it.
Any objection?
No, Your Honor.
OR, obey all laws, make all court appearances, comply with CPS, pretrial services supervision, next court date, February 6th at 9:30 a.m. for filing criminal complaint. We'll see you then. Thank you, sir. Pool should be our last matter, and there are 2 cases. All right, what does Steve feel appropriate on these 2 matters?
Yes, Your Honor. So in this case, in these cases, we are going to be asking for $500,000 bondable only bail on each one for a total of $1 million. We are also asking for no contact with the victims in these cases. I would note we did speak with the victim, Juliana Rodriguez. She's the victim from the 2015 case. Although she indicates she doesn't feel the need for a no contact order, she said she's not afraid of the defendant, but she's extremely uncomfortable around him. However, again, given the facts here, the state is requesting a no contact order with her pursuant to NRS 178, such as a new and subsequent offense. We would also ask for GPS house arrest, given the allegations here. Regarding the case with Miss Poole, where her children are the victim, she says she does want a no contact order. So again, we're asking for a no contact order with her and the victim, Brooklyn, pursuant to NRS 178, such as a new and subsequent offense. She says she's afraid of the defendant and her kids are afraid of him. She states he was also physically abusive towards her. And so she's concerned for the safety of herself and her children. She says that she's unsure of mental health or drug issues, but says he's an alcoholic. States he does not own weapons. And both victims were provided contact. I don't believe any of they both indicated that they were not going to be present. The defendant has admittedly a fairly low MPRA score at 4. I show a misdemeanor conviction of assault. That was back in 2011. However, again, given these concerning allegations, the length of time between these shows that this defendant is clearly an ongoing risk. And frankly, given the admissions that he made to officers, he's at a high likelihood of conviction on these cases that carry an extremely large amount of prison time and other ramifications. And so therefore, due to the risk of the community, the risk of flight, given the serious penalties here, we believe that high bail is appropriate and ask that you set that bail at those conditions. Thank you.
All right, thank you, defense.
Thank you, Your Honor. Our team was able to speak with Mr. Poole's references, a friend who confirmed an address where he can reside with her. He could be on GPS monitoring and house arrest at that residence. She also confirmed his employment at Panasonic. He did receive points on the MPRA for employment, but again, we were able to verify that and that he's lived in the area for all of his life, has strong ties to the community. He would absolutely abide by all of the no contact orders that were just outlined by the state. Understanding these are quite serious charges. Mr. Poole lacks financial resources to post much money bail at all, certainly not what's been requested by the state. He, again, is not able to work while he's incarcerated, could possibly come up with a limited amount of money bail, $20,000 for these cases. Again, with the conditions of following all the no contact orders, and he could be on GPS house arrest with a residence that's been confirmed. With those options, we believe those are less restrictive options than the very high monetary bail that the state has requested.
Thank you. Again, very difficult when we don't have officers anymore to enforce these conditions on individuals like this. It certainly changes the least restrictive means analysis, but that was the county's decision over our objection. In this case, there is no least restrictive means other than bail outside the defendant's ability to make it. What the United States Supreme Court has said about the Eighth Amendment and the right to bail is that there is no right to be able to make bail. The issue is the bail set excessive in light of the perceived evil? And I can't find that $1 million is excessive in light of the perceived evil in this case. So it will be set at $1 million, no contact with the victim, separate criminal offense pursuant to NRS 1784845 for the maximum 120 days, no contact with any other minors as well. Ankle bracelet in place before release to ensure compliance as well as residential confinement. Pretrial services supervision, obey laws, make all court appearances. February 6th at 9:30 a.m. will be your next court date, sir. Good luck to you. Anybody else up at the jail?
There is not, Your Honor.
All right. Have a great rest of your Sunday.